A court hearing turns tense when a woman admits using marijuana for cancer pain, but things escalate fast when the judge delivers a second chance that could change her life forever. What happens next will shock you.
Explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management records. And I will promise you on Jesus' happy golden good soul that I will never touch this shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am.
Okay, so Ms. Willilifford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We can agree to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true? And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs safety program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today. And is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Willilifford is not competent?
There you go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. It looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs safety program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of safety. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you. Explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management records. And I will promise you on Jesus' happy golden good soul that I will never touch this shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'll get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am.
There's all kinds of other ways to deal with issues. And there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now. Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. For 0523, you're charged with a first-degree felony offense of murder from April 28th of 2025. And what that means, sir, is that if you go to trial and you're found guilty in that offense, the range of punishment would be between 5 years and up to 99 years or life in prison. Do you understand the range of punishment?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with a state jail felony offense of unauthorized use of a vehicle from October 15th of 2024. What that means in that case is that if you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes, ma'am.
And then in cause number 25, DCCR 1352, you're charged with a first-degree felony offense of aggravated robbery from September 18th of 2024. What that means in that case is if you go to trial and you're found guilty, the range of punishment is a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
And then finally, in clause number 25, DCCR 1353, you're charged with the second-degree felony offense of robbery from September 18th of 2024. And in that case, what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then I have here on the tablet in those cases some plea bargain rejections that you've signed with Mr. Wilkerson. They show that the district attorney's office has made an offer if you wanted to enter pleas of guilty for a 35-year term in the murder case to run concurrently with a 35-year term in the aggravated robbery case with a dismissal in the robbery as well as the state jail felony unauthorized use. Is that correct?
Yes, ma'am.
Do you understand what their offer is?
Yes, ma'am.
And have you gone over it with Mr. Wilkerson?
Yes.
And do you want to reject that offer and have all 4 of your cases set for trial?
Yes, ma'am.
All right. Is there any reason to expect that those offers would change any evidence that you're waiting on that you guys haven't received or gone over?
No, Your Honor, not at all. In fact, the state will be, will likely be filing a motion to accumulate the sentences to the extent that they can. I think 3 of them come out of one occurrence, and then there's one from a separate.
You've actually got 3 different dates. So you've got ag robbery and robbery from September of 2024. You've got an unauthorized use from October of 2024, and then the murders from April of 2025.
To the extent we can accumulate all of those, Judge, we will seek to do so.
So I want to make sure you understand, Mr. Jones, that if you are found guilty in more than one of these offenses by a jury, the state can file requests that I stack or run cumulative, which means stack on top of each other any punishment that you receive. Do you understand that as well?
Yes, ma'am.
And that after today, I will not accept this agreement for a 35-year term. If you change your mind later, you can enter a plea open to the court. You can enter a plea to something different, but it's not going to be 35 years. Do you understand? All right. And do you want to have all of your cases set for trial?
Yes, ma'am. I got a question.
Yes, sir.
My offer 35, right? That's what the DA's offer, right?
Uh-huh.
My co-defendant admitted to it, but he got a 30-year off.
Here's the thing. Your offer is what your offer is. He may or may not have had the robberies before he would. Listen, I don't know. I know the offer is what the offer is. All right? So either you take the offer or you go to trial and let a jury decide. I'm not involved in negotiations. I'm not going to tell the district attorney's office what to do. That's not my job. But you don't get to, everybody has different issues in their cases that they feel important and why they would make different offers for different co-defendants. All right. So you're not going to have a different offer. And that's what I want to make sure you understand. Even though there was something different for your co-defendant, the district attorney's office has said, this is it. This is your offer. Do you understand?
Yes, ma'am.
Okay. And you want to reject it and go to trial.
Yes, ma'am.
Okay, we'll get it set for trial, and Mr. Wilkerson will be in preparation. You can go
Thank you.
back with the bailiff.
Thank you, Your Honor.
The stakes are high, second chances are rare, and every decision matters in this courtroom. If you want more jaw-dropping courtroom drama and real-life legal battles, hit that subscribe button now and never miss an update.